law, then it simply means that according to that law, then the alcohol limit would be 0. So it means that you're not supposed to be found with any alcohol in your blood, but it has not yet come into play. So as it is, it remains at 0.05 grams.
Okay. And what are the penalties that one can expect to face if they are found guilty of drinking and driving?
One of the penalties that can be imposed if you are found for driving under the influence of alcohol would be that, you can either be fined, and the fine might not exceed 2,000 rand, or secondly, you can be given what we call a suspended sentence. So by suspended sentence, it means that the court can say that we are imposing a fine, we are also imposing imprisonment, but we are suspending it for a specific period. And during that period, you should not be found guilty of either the same offense or offense that relates to drinking and driving. When it comes to jail sentence, the court may sentence you up to 36 months. So those are the current sentences that we have.
Okay. And can you take us through what one can expect if I do get pulled over and I'm suspected of being under the influence? What happens if you are caught and you are arrested for drinking and driving?
Well, if you are arrested for drunk driving, what would happen is that, let's say you get pulled over, as you've said it, definitely you will be arrested. And then once you are arrested, what has to happen is that the police are supposed to charge you. And once they charge you, it's important that within a period of 48 hours, you should be brought to court so that you can either apply for bail in that instance. And it's very important that if you are pulled over for purposes of alcohol, it's important that within a period of 2 hours, you are supposed to be taken to either the hospital so that they can draw blood within 2 hours to confirm, and do a test as whether there's alcohol. But obviously the result would be sent to the lab.
Okay. And obviously, if you are drinking and driving, you have your car that could also get you into a bit of trouble. How does this affect your car insurance, for example?
You see, with your car insurance, remember that with insurance, it's a matter of saying that you entered into a contract with an insurance company, right? Some, I'm not saying all, sometimes it can happen that, let's say that you get arrested, and then when it comes to the insurer, you might be able not to claim from the insurer. It is an unlawful conduct. You are found into an unlawful activity. So as a result of that, you might find that it's part of the exclusion of maybe your policy that you took with the insurer. So it depends on the terms and the conditions of the insurance between you and the insurer itself.
Okay. And how long can one expect to be detained for in a drinking and driving case? How many days would you be, held in jail?
Well, it's 48 hours. The 48 hours rule applies. So if you are detained, it's a matter of saying it should not exceed 48 hours. Within 48 hours, you are supposed to be brought before a court of law so that you can apply for bail.
Okay.
So that's how it is.
And would this leave a permanent taint, as in, are you at risk of getting a criminal record due to this?
In an instance whereby you are found guilty, you'll definitely get a criminal record because it's an offense that is listed in the Criminal Procedure Act. So you found guilty, it will be entered on your record and you have a criminal record.
Okay. And can you lose your driving license?
Normally what happens is that after you have been found guilty in a court of law, there is what we call an inquiry. So what will happen is that the court will give you an opportunity to state as to why it should not suspend or endorse your license. So now, if the court is not convinced by what you said during an inquiry, so definitely they can either suspend your license or endorse your license. It just depends on what you said during the inquiry. Yes.
Okay. All right. And then if you get pulled over and you happen to have passengers in your car who are also indulging, can they be, are they legally allowed to be in a car drinking, like yourself?
Yes, but with passengers, remember that passengers, they're simply the people who, they are people who are not driving. So now, if they are found driving, they are not the one behind the wheel, because as it stands, as legislation stands, the person who gets charged, it is the driver for driving under the influence of alcohol, not the passengers. So with the passengers, they are still safe for now, but we're still waiting for this new law to come into effect, because as soon as it comes into effect, it's zero tolerance, no alcohol.
Okay. Even for passengers?
Even for passengers.
Okay. All right. And how does one get tested for their blood alcohol levels?
Well, what would happen is that, let's say you get pulled over, they'll use what we call a breathalyzer test to check if your alcohol, the alcohol content in your blood, does it exceed 0.05 gram? So that's how they test you if you get pulled over by the road. They use the breathalyzer test.
Okay. And do you have to be breathalyzed first? Because I know that they also take a blood test in some cases, but do you have to follow protocol where you start with the breathalyzer test, or can they just decide to take the blood test?
Look, what happens is that there is what we call circumstantial evidence in criminal law. By circumstantial evidence, we mean that, for an example, let's say that you get pulled over and then the police officer is aware that your speech is impaired, or maybe there's redness in your eyes, or maybe you are unable to stand steady. So at the face of that, there is circumstantial evidence that can suggest that this person might be drunk. So if it's then in that way, under the circumstances, I'm not saying that they can conclude. They can say that this person might be drunk, and then obviously they'll have to take you to the hospital so that blood can be drawn within 2 hours to check if indeed there is alcohol content in your blood which exceed the statutory limit.
Okay. And
Yeah.
what happens if I refuse to submit to a blood alcohol test?
Well, if you refuse to submit to for alcohol, they cannot force you. But remember that there is what we call circumstantial evidence that I've already said that, if they are saying that you could not stand steady, maybe your speech was impaired, then they will not charge you. If it gets to a court of law, they will not charge you of driving under the influence of alcohol. The reason for that is because they will need, evidence to say that it was above the statutory limit. So what they will charge you of, they will charge you with what we call a competent verdict of drunk driving. Maybe they can charge you of a reckless driving. It will just depend on how the prosecutor wants to formulate the charge when it gets to court.
Okay.
So yeah.
All right. Thanks. Thanks, Sonia.
Okay.
Leo, I'd like to move over to you. And one of the major issues, and I think it's something that we've also dealt with within our organization, Legal&Tax, is the fact that people end up paying an admission of guilt fine. I don't know whether it happens because they feel like it's the only option at that point, because, you know, who wants to get arrested and go to jail and spend a few days there? So you end up feeling maybe backed into a corner a little bit, as if this is your only get out of jail free card. So firstly, can you explain to us what is admission of guilt?
Okay, so admission of guilt or an admission of guilt fine is part of our legal system. So it allows a person to admit guilt without having to appear in court. So this option is made available it prevents an unnecessary overload of our court system. So what happens, it allows the accused to take responsibility of having committed a less serious offense, and it assists the state to resolve these minor offenses quickly.
Okay. And is an admission of guilt a conviction?
Absolutely. So what happens is that when you pay an admission of guilt fine, you are deemed to have been convicted and sentenced. And your name will be recorded in the criminal, a criminal record, will be recorded against your name in the criminal record book.
Okay. And can you take us through, I mean, you know, in that situation where you feel like you are backed into a corner and you feel like that's your only way out, what should people know about being arrested? What are your rights if you ever find yourself in that kind of situation?
Okay. So, well, when you are arrested, subsequently you'll be detained, right? Mm-hmm. So when you are arrested by an arresting officer or police officer, they need to read you your rights. And these rights are that you have the right to remain silent. You have the right to be informed of your right to remain silent, because what you say or admit can and will be used against you in a court of law. You have the right to be released from detention. You have the right to be released from detention if the interest of justice permits. Because remember, if you have committed a more serious offense or you are a habitual criminal, the court cannot just, release you from detention if you are that type of criminal. Okay. You have the right to contact or consult with your attorney. And if you cannot afford one be assigned to you by the state. You have the right, when you are detained, you have the right to be contained in conditions that are consistent with human dignity. So this means that when you are detained, you have to be provided with accommodation, a nutritious meal, reading material, or a place where you can exercise. And if you fall sick, medical treatment, all at the state's expense. You have the right to basically, the most important one, I think, according to my opinion, is the shining star of all these rights, is that you have the right to be presumed innocent until proven guilty.
Okay, we've heard that one in quite a few movies, so yeah. And when does the affordability, if I might call it, of you being offered bail, when does that kick in?
Okay, so we have basically three types of bail, right? We have police bail, prosecutor or prosecutorial bail, and court bail. So police bail is may be paid for offenses that are minor, right? But then you have to apply for this bail within the 48 hours of you being detained at a police station. And it has to be, applied for before your first court appearance. But like I said, only for minor offenses and, for example, theft. So whatever you stole has to be, the value of what you stole has to be under 2,500 rand. And then we have prosecutorial bail, which is for more serious offenses, where even when you are detained at a police station, there's usually a prosecutor who's on duty, but it's for more serious offenses, like I mentioned, and the prosecutor has to be at the police station at the time. But it's a more serious offense. You cannot exceed a fine that is over 20,000 rand. And court bail is, you're arrested, you're detained, and it is your right that you must appear before a court of law within 48 hours. But it's more, formal. You have to appear in court. And the prosecution either has to oppose or allow you to post bail. It would then depend, obviously, on the type of offense that you have committed.
Okay. And then under what circumstances can you be released on just a warning?
Okay, so a warning, it's not like, a mother warning a child that, I'm warning you, you have committed this offense, you can go. No, we sometimes refer to it as free bail. It's the same as being released on bail, but you just don't pay a certain amount. All right. You can be released with conditions. For example, the condition can be that you have to report to your nearest police station weekly before your court appearance, for example.
Okay, all right. And does a traffic fine, for example, go on your criminal record?
No. I mean, probably be in jail. I'm not saying anything.
Okay. Yeah, don't implicate yourself.
So no, it does not result in a criminal conviction. So unlike other criminal offenses, because it is a criminal offense, to not adhere to the Road Traffic Act. So unlike this particular offense, is that it is governed by a different statute. So it's not governed by the Criminal Procedure Act or Criminal Amendment Act. It is governed by the Road Traffic Act and also the Administrative Adjudication of Road Traffic Offences Act, which specifically stipulates that such a fine, for example, you get fined, when you don't adhere to the rules of the road. So such an act, the acts that I mentioned is that it specifically stipulates that such a fine not be, a criminal conviction will not be recorded against your name.
Okay, that is good news. And can you share with us how we can assist our members here at Legal&Tax if they do find themselves in a rut and they've been arrested?
Okay, so our members, they know, they have to call us. So for example, if you get arrested during business hours, you contact our call center and you inform the call consultant that you have been arrested. So what is important is that when you are arrested, when the police reads you your right, they will inform you that you have the right to contact your attorney. So you need to inform them that you have an attorney that you can call. You request to make the call, but you need to get all the details: where you've been arrested, which police station are you being held, and who's the investigating or arresting officer who is currently handling your matter. And it will come through to us, and we will assist you and assign an attorney who can come and assist with your bail application, depending obviously on the offense that you committed. We also have an emergency after hours bail services. When you are arrested after working hours, you are still able to contact us and we will assist you accordingly.
Okay. And what advice can you give our clients if they find themselves in such a predicament? I mean, I can imagine you're scared and you might not know where your first point of contact should be. So what advice would you give to our members?
Okay, I'd advise our members to, be calm, do not panic, because when you're panicking, you cannot think. So stay calm, do not pay anything, do not sign anything, because we've had instances where our members would, for example, think that they are posting bail, they are paying a bail amount, but they're actually paying an admission of guilt fine. So ask questions, do not be scared, do not panic, know what you are paying for. Do not be scared to ask the police officers questions.
Okay, thank you. Thank you so much, Will. Sonia, back to you. I'd like us to look at some of the COVID-19 regulations. I mean, the past 2 years has been quite stringent on a lot of us, when it comes to leisure and being able to be on the road and, just leaving your house. It seems like there's just a lot of red tape, Obviously, things have eased up a little bit, and we're very happy about that. But there are still a lot of rules and regulations in place when it pertains to COVID-19. I'd like to just, learn more about what penalty does non-compliance or a violation of COVID-19 regulations carry? Sonia, you're on mute.
Okay, can you hear me?
Yes, we can hear you.
Okay, the penalties that you can get for breaking the regulations, or let me rather use the word violating the regulations, is that you can either get a fine or you can be sentenced to an imprisonment not exceeding 6 months. So those are the penalties that you can get at the stage as mandated in the regulations.
Okay. And what are some of the transgressions that could land you in trouble?
Look, one of the transgressions that can land you into trouble, especially when it comes under the ambit of COVID regulations, it's obviously if you break the curfew, you are found in the streets during the time of curfew without having a valid permit to say that you are supposed to be there. And then secondly, the other one that can land you into trouble is if you are in the public space without a mask. We are mandated to wear masks, but the offense comes when a lawful instruction by a police officer, maybe a police officer said that you are in public, you're not wearing a mask. That is when it becomes a transaction, what is the word?
Transgression, yeah.
Yeah.
Okay, all right.
Yeah.
And if someone is arrested for maybe, example, breaching our curfew, what should they expect? What steps will follow after that that transgression?
Well, what will happen is that you will be arrested. And then if you are arrested, just as, my colleague has highlighted, when it comes to different types of bails, you still have, a right to either apply for bail there and then. So it just depends on the circumstances as to whether the police choose to take you to court to formally apply for bail, or whether they choose that they're going to grant a police bail. So those are the options that are available to you if you get arrested.
Okay. And then in that specific situation, so if you are busted for breaking curfew, would you advise our members to pay an admission of guilt fine to avoid going to court?
No. I honestly don't advise our members to pay an admission of guilt. The reason I don't advise our members to pay an admission of guilt fine, it's that just as Rio has highlighted that you will definitely get a criminal record under your name. So now, allow this matter to go to court. And then if it gets to court, and obviously let's say you did break the curfew, there is what we call diversion in our criminal procedure act. So by diversion, it means that you acknowledge the guilt. Yes, I did it. Yes, I was found in the street after hours. So then what can happen is that your attorney can request the state prosecutor to divert you. So diversion basically means that they send you to some programs, either with a social worker. You find that sometimes you just have to attend them, let's say 3 times. It just depends. And from there, after they get a report, after getting a report, it becomes a matter of saying that the matter can be withdrawn against you.
Okay.
So now it's an option that is available just to, shy away from having a criminal record.
Yeah. Okay.
Yeah.
No, got it. Do not sign an admission of guilt fine.
You know,
Don't do it. Okay, thank you, Sonia. Vuyo, let's jump back to you. Firstly, I mean, we know, especially being on the roads in Johannesburg, what tends to follow after you've been stopped or pulled over by a police officer. Even if you're not in the wrong, they'll find something and then they want a cold drink, as we as we say, they want a cold drink. Can you share what should you do when a police officer asks you for a bribe?
Okay. Do not quench that thirst. Do not pay a bribe. I know it's tempting and it's convenient, right? And you can pay less to bribe the police officer than to get a ticket for 1,000 rand, for example. But do not remember, bribing is corruption. You are partaking in corrupt activities. So no, and you may be prosecuted. So don't do it.
Okay. And can one go to jail for bribing a police officer?
Yes. So corruption and bribery and extortion are governed by the PRECA Act, Prevention and Combating of Corrupt Activities Act. So you may land yourself in jail for bribing or offering to bribe a police officer.
Okay, all right. And in a situation, I've heard stories where people have been assaulted by police officers, especially following maybe you decline to pay a bribe and things escalate and they become physical. What do you do when the police violate your rights physically, or even, if it's a verbal altercation? What do you do in that instance?
Okay, so it will depend on the specific violation. So let's say you are assaulted by a police officer, or you are even raped by a police officer. You can you can pursue a civil claim against that specific police officer, obviously in the employ as a representative of the SAPS and the Minister of Police. But if you are, let's say, for example, you're unhappy with how they're handling your case, or the particular, constable or police officer is not handling your case to your satisfaction, then you can report the matter to the station commander.
Okay. And then in a situation where maybe your car was raided or even your home, and some of your property was confiscated by the police, can you get it back? And, how do you go about doing that?
Okay, it will also depend on the property. Let's say, for example, you had, some grams of coke or dacha. It's an unlawful conduct to have those in your possession. So they will confiscate it and you will not get it back. But let's say, for example, you were in your car, but you had stolen goods in your car, for example. the police officers may confiscate your vehicle, and you can only get it back after the conclusion of the investigations or after the conclusion of the matter. You
Okay.
will times you will forfeit it to the state.
Okay. All right. And lastly, are the police allowed to search a person without a warrant, or even arrest them without a warrant?
Yes. The police officers can, because remember, you can be arrested on the strength of an arrest warrant, right? You can also be arrested when a police officer witnesses you committing a particular offense, or only on the suspicion that you have committed an offense, then they can arrest you. Because I mean, I see you committing an offense, I don't have time to run around to get a warrant from a judge. The laws allow that they arrest you without an arrest warrant.
Okay. And then if you've
Sorry.
been, yes?
Yeah, continue.
Oh, so following a booking, if you've been arrested and obviously your fingerprints were taken and now your information is on the police system, how do you go about clearing your fingerprints from the system?
Okay. So when your fingerprints, actually, I wanted to go back a bit to admission of guilt fine. But thank you for giving me this question. So what happens is that when you pay the fine, for example, or you've been arrested and convicted in a court of law, or you have paid the fine, the police will take your prints when you are arrested and detained, take your prints, and also take photographs, right? So when you are convicted and sentenced, this record stays against your name for life, okay? But it will depend now on the particular offense that you have committed. If you paid an admission of guilt fine, it means you have only committed a minor offense. But there are people who, for example, commit, grievous offenses like sexual assault and rape, like that. So only if you committed a minor offense and not an offense that is serious that includes rape and sexual assault, you can apply to have your record expunged, right? But you can only do this after a period of 10 years has elapsed, right? You make an application to the Director General of the Constitution, Department of Justice and Constitution to have your record expunged. But they only take into account minor offenses, and only if you have not committed a similar offense during this 10-year period, right? So just remember that it does not automatically go away. You have to apply to get your record expunged.
Okay. And how long does the process take, roughly?
I don't want to demotivate anyone, but it does take some time, because you know how a government is. So you just have to be, patient with this one. It can take up to months,
Yeah. Okay,
Yeah.
great stuff. Now I see that we have quite a few questions from our guests, which is lovely. Love it. And Michael, I'm going to ask you to step forward. You're on mute, Michael.
I'm having so much fun typing back to the clients and the questions.
Oh, nice.
I'm just listening in the background.
Amazing. So we've got a question here. If you admit to an offense, considering it's regarded as a criminal record, I'm assuming it's the admission of guilt fine. So if you admit to it, do the police service take your fingerprints?
Okay, with regards to that, they should remember that your admission of guilt fine, it's not on the spot always. So it could be that they already started they took you into the police station and took your fingerprints, and then let's say you go to court and the court decides, okay, well, listen, there's an admission of guilt fine payable. Then you would pay it at a later stage and they already took your fingerprints, etc. And you also have the smaller types of admission of guilt, usually with speeding and those types of things where they don't take your fingerprints. So the process is not really linked to taking of fingerprints and going through that process. So it could be, it could not be. Just depends when it happens.
Okay, all right. And another question. So do you call your attorney while you're still on the side of the road, or do you only call after you've been arrested and you're physically sitting in your jail cell?
Depending on how much trouble you're in. Okay, so if you have access to a telephone, it would be a good idea to call your attorney if you know that something might come up. Most of the times it's not a serious issue. So let's say, for example, you get pulled over, you have not drank that night, you're not after curfew, nothing is wrong, then they might just be doing a spot check. Then it's not necessary to call your attorney instantly. But if you know that something might come up, it might be a good idea to either let an attorney know or a family member know what's going on, because they might confiscate your telephone later on. It is a situation where, although you have certain rights, but these rights that you have, you are able to make contact with a family member or etc. while you are, let's say, at the cells or at the police station. This is within the 48-hour period. So you do have a situation where, yes, you can make contact with your attorney, but we'll give you your chance in 12 hours. So if you are next to the road and you know something might go wrong, while you have your telephone, call a family member, call your attorney, and in that situation, just prepare for the worst. Might not have to be the worst, but just prepare. So once again, it depends on the situation. But if you have the opportunity to do it while next to the road and you know that you are going to be arrested, rather just do the preparation.
Okay. And then if a police officer is the one to initiate a bribe, how do I go about reporting it, and what evidence is needed to substantiate your claim or the charge?
They do have a dedicated line with regards to it. I think we can post it up somewhere later. Maybe I can look it up. But in that situation, if there was an attempted bribe, you will have to report it via the police procedures. There's complaints@SAPS, if I remember correctly, that's the email address. If it is serious, you can escalate it to iPad. Either if you know who's the station commander, you can report to them as well. But yeah, you need to report it. I'm just at this point in time I can't give you the information for this is the email address, this is the telephone number, etc.
Okay, all right. No, we'll definitely post that on our website. And then in the case of a raid and there is damage to one's property, can one claim this from the Minister of Police?
Possibly, yes. I did see that question. I couldn't type fast enough. With regards to that, yes, you may claim certain damages from the Minister of Police. I do want to bring this up. Maybe I should discuss it now. When you have a claim against the state, there's certain things that you have to have a look at. When I'm going to bring a claim against the state, I need to notify the state in terms of Act 40, Section 3 and 4, that I'm going to lodge a civil claim against them. That must be done 6 months before 6 months is over from when the incident happened. Okay. Then also, with regards to that, these types of cases, it's not a fast case. Now, litigation and court proceedings usually don't go fast. But this is especially long because you have a situation where there's a lot of these claims. It's dealt with by the state attorneys, and there's also things that falls through the cracks. So you'll have a situation, you send the notice, you send the summons, they don't defend it. Then you apply for default judgment. Then suddenly the state attorney pitches up and says, oh, hello, sorry, we never received the summons, or there was a change of office or whatever. Then they go back and then they need to file a plea in the defense, and then they continue, and then they miss a few steps again, and then you have to go to court again. So it might take a while, but yes. And also if it was lawful, or let's say within reason, let's say we do a raid on a property, we ask entry, assuming now I'm a police officer, not a very fit one, but let's say I assume I am one. We ask entry and we try to gain entry and there's a refusal. then in that situation, we are within our rights to break down the door or the gate or whatever. That is within reason. But if it is a situation where we just barge in with no good reason, without a warrant, without anything, and just cause havoc and try and intimidate you, of course, you have a civil claim there.
100%. Okay. And then in closing, Michael, what would be your final take-home message for all our guests?
Yeah, there's a few things that I want to bring up, of which one I now discussed partially. With regards to drinking and driving, remember, even there's a rule, and I don't know where this rule comes from, where people say no, but it's 1 unit of alcohol per hour. And if you wait an hour and you had 1 drink, then you're fine, you can get on the road. This is not a tested method or 100% method. It depends on your metabolism. It depends how fast your liver can go through the alcohol, etc. Depends how large you are as well. So if you are going to drink, rather be safe. Get transport somewhere, or someone picks you up, or rather walk if you can. It's not worth the effort. It's not worth the risk. As even if you, let's say they arrest you. Okay, you had your 2 beers at 6 o'clock and you did not drink anything till 9:30. Now you get in your car and you drive home to get home before curfew. You feeling fine? Most probably you are fine, but then they might smell alcohol on you, or they might think that you have consumed alcohol. Then you still have to go through the whole rigmarole of going to do the blood test, going to the police station, getting everything done, getting your fingerprints, calling your wife, and your wife is angry with you. Then you need to appear the next day, or they say, okay, you get bail and you need to appear in a month or whatever. Then you need to go and appear. All this could have been avoided, because most probably you're not. Let's say you get to court and then the docket comes and say, okay, you weren't positive. Then they throw the matter out. But you lost 4 or 5 days of your life in terms of this process just for taking a chance. I know there are situations where there's an emergency and you need to get in the car, etc. But please try and avoid these situations, as it is usually more hassle than worth it. Also, expungement of criminal records. Do remember that your criminal record can be expunged, but only after 10 years and under certain circumstances. So let's take just general things. There are a few certain rules with regards to old apartheid acts, etc. But I'm not going to concentrate on that. I'm going to concentrate on the normal admission of guilt, etc. The big limitation is you cannot expunge a criminal record that was, for example, for rape, sexual assault, violence against a child, etc. That's going to stay permanently. But for drinking and driving, small things and admission of guilt fines, yes, you can expunge them after 10 years. But remember, this is an administrative process. This is not walking into a police station and saying, okay, thank you, it's been 10 years, please remove me from the system. No, you need to go and get a police clearance first. Then you need to apply on a form, I think it's J744E. You need to send that to the Department of Constitutional Development, and then they need to then run through your application, and then they need to decide, can your matter be expunged or not. So once again, it's not a fast solution. So if, for example, you get a criminal record and you pay the admission of guilt fine, do take note that you'll actually have to go and expunge it. It doesn't happen automatically. It doesn't prescribe over a certain period of time. Also, the other thing that I did want to discuss was claims against the state. Please take notice thereof. When you have a claim against the state, usually when you have an attorney, they will do it in terms of contingency, because it is such a long-running matter that sometimes you only get paid out. Let's say, I'm going to take a typical example. I was wrongfully arrested. I was not treated well within the prison cells, and let's say I was assaulted. Now we start this process of giving the Act 40 notice. We do the summons. Let's say everything goes well and it goes to trial and the trial is heard. Now we still have to get payment from the state. If the state doesn't pay, you still have to do a warrant of execution, trying to force the state to pay. These things take time. I've seen matters anything from 4 years up till 9-10 years. So it's not a fast thing that happens. If, for example, in any criminal matter, if you are the victim, if you have physical let's say you were assaulted or you have any physical injuries, do not leave this matter for 3 weeks later to go and report it. It's important to go and report it early on, and then also to go and also do the medical, your J88s, to go and do the medical reports and everything with regards to it, because it's time sensitive. You heal over time. So if I was assaulted today and I have 2 black eyes and I can't see out of them, there's no use in me going in 4 weeks to the police and opening up a charge of assault. And then they say, okay, but listen, where's your medical reports for your damages and things? So it's just something to take note of. Yeah, and I think off the top of my head, those are the 4 of the things that I could remember now.
Nice one. Amazing. Wow. I was like proper glued in there. Like, yeah.
Just running through it at the speed of light, just going.
Yeah. Very informative. Thank you so much, Michael.
Okay.
Sonia, over to you. What would you say is your final message to our audience?
Don't drink and drive. It's a very serious offense. You can lose your license. And once you lose your license, some of the people, you find that they're using their license as drivers to put an income in their houses. So it's very important that they should take note that their license may be suspended or endorsed. And it's very important to ensure that you keep the regulations, rules as they are. Don't break the curfew, wear your mask in public, because if you break those things, the penalties that I've already mentioned, that you may be sentenced up to 6 months, or you may even get a fine, you'll definitely get them, and you'll definitely get a criminal record, and have to wait for a period of 10 years to wait for that to be expunged. So it's better to be safe, than be sorry. So that's what I want to say to our listeners.
100%. Thank you, Sonia. Last but not least, Vuyo.
My last words is that please stay on the right side of the law. A criminal record can inconvenience you, because when you have one, it affects your future job prospects or future career. You cannot apply for a job because you have to disclose, and most employers do not take, employ people who have criminal records. And also when you have one, you can't apply for a visa. Don't you want to leave South Africa and experience the world? You also cannot apply for a firearm if you are that type of person that's into that. So please stay on the right side of the law. Thank you.
Thank you, Vuyo. Thank you, guys. Wow, it's been an amazing hour with you. It always is. I look forward to these sessions because I learn a lot, so I can imagine what our audience is also, picking up, yeah, we need to be so careful on the roads. And if any of our members have a criminal matter and they need our assistance, we are your companion. We are here to help you navigate these very, turbulent streets. And if you do have a matter and you'd like to speak to one of our legal advisors, please call us. You can call us on 0860 587 587. You can also WhatsApp us. Our line is 071 526 8527, or send us an email. That would be to info@legalandtax.co.za. And yeah, thank you so much to all our guests for joining us this afternoon. I'd like to thank Sonia, Vuyo, and Michael for being our panelists and sharing your knowledge and your expertise with us. Thank you so much. I'm so grateful. And yeah, thank you, and enjoy the rest of your afternoon, everyone. Cheerios.
Cool. Thank you for the opportunity. Always a pleasure.
Awesome. Thank you, Michael.
Okay,
Cheers.
bye.
Cheers, everyone. Bye-bye.